Being aggrieved, the private respondents filed a revision before the Deputy Director of Consolidation under Section 48 of the Act 1953, who vied his judgment dated 25/6/2002, upheld the order of the settlement officer of consolidation of the ground that a preliminary decree is a final determination of the rights of the parties in respect of the property sought to be petitioned. It is also applicable, but no such appeal was filed by the petitioner herein, that is, respondents, before the revisional court. On the allegation of fraud, the court persuaded the records and found that there was no pleading containing requisite denial of thumb impression, nor the presence of the concerned in the court, etc., nor evidence to prove any such fraud. The revisional court relied upon the decision of the Supreme Court reported in AIR 1995 SC 2493, Mulchand and other versus Deputy Director, Consolidations and others, to hold that a preliminary decree passed in a suit for partition under Section 176 binds the parties, even those proceedings do not result in a final decree, if a said preliminary decree is not challenged in appeal. Therefore, the preliminary decree dated 1/3/1986, passed on the basis of compromise which had been duly proved, was binding upon the petitioners and also operated as estoppel, and principle of acquiescence also applied. The contention of the learned counsel for the petitioner is that no such compromise was entered into within the private respondents, and he had no knowledge whatsoever about the said preliminary decree. Once the suit abated, the preliminary decree could not have been appealed, as any proceedings could only take place before the consolidation authorities. Plea of fraud was taken before the consolidation authorities, which was fraud to be correct by the settlement officer, consolidation, and rightly so. There was no reason for the petitioner to enter into a compromise relinquishing 1/3 share and accepting 1/6 share of the holding, but the revisional court, without appreciating these aspects of the matter, has erred on facts and law in upturning the judgment of the settlement officer of consolidation, causing prejudice